Public international law or making sure international law is sometimes called the law on nations. Okay, firstly, did you familiar with the guy the name Reynhard Sinaga and the case in Myanmar, especially focusing with the Rohingya? Okay, this video will be focusing on the crackdown on the United Kingdom against Reynhard Sinaga in UK and Malaysia dispute toward ethnic Rohingya that entered the region illegally. In this video, there are two cases that have different themes. The first theme are international criminal law and the international humanitarian law. So what's happened? International criminal discuss topics that are the thought of most of the world community, especially in Indonesia and the United Kingdom. Reynhard is an Indonesian citizen who was sentenced to live imprisonment for having been raped by more than 150 people. Oh my god, yes. But one of the obligations of the Indonesian government is to protect citizens who are facing legal problems in other countries. So it can be confusion. Is protect the citizen or protect the criminal? And for the second case, in February 2020, close to 180,000 refugees were registered in Malaysia through the UN's Refugee Agency, United Nations High Commissioner for Refugees, or we know that UNHCR. However, during the Movement Control Order, or MCO, in Malaysia because of coronavirus or COVID-19, there was a boat carrying some Rohingya refugees that entered Malaysia, but due to enforce the Movement Control Order, which among other prohibit foreign nationals and vessels from entering the countries. Malaysia has respected the convention all along based on humanitarian considerations, but the problem is Malaysia not a signatory to the UN Refugee Convention.
Reynhard Sinaga is an Indonesian man who was convicted with 136 counts of rape, 8 attempts of rapes, and 14 sexual assault, and was named as United Kingdom's most high-profile rapist. He is known to rape hundreds of men in the United Kingdom between January 2015 and June 2017. Sinaga lived in a flat at the heart of Manchester City known as the Montana House, which is located about 400 meters away from the gay village. The modus operandi of this scheme is Sinaga would linger around Princess Street to prey on his victims before offering them his charger for them to charge their phones or a place to stay for the night, since the victims were experiencing a vessalgia, shaping a constructive reality that he is a good Samaritan. Sinaga was convicted at the Manchester Crown Court in 4 trials and was prosecuted between 2018 and 2020. Sinaga was found guilty for all the charges due to the substantial evidence that was presented, which was his 2 iPhones that Sinaga used to film his crime. He was sentenced to 88 concurrent life sentences at the HM prison, Manchester, with a minimum term of 30 years. In this case, the actors involved are the British government and Reynhard Sinaga as an individual, and he is not represented by the Indonesian government. This is due to the act of the crime, which involves British nationals and the location of the crime. Thus, the Crown Court is able to try him at the court for his offenses against British nationals.
In this case, Reynhard Sinaga staying abroad for education purposes. So during his staying there, he committed a sex crime and got sentenced to a life imprisonment. So we as a group would like to know on how the judgments and the jurisdiction for his crime as he committed it abroad, and we would like to know the responsibility for both the home state and the convicted state. It's like on what is the right of the convicted.
Sinaga's case is rather crucial, and it is a critical subject in both Indonesia and the United Kingdom. A media blackout is imposed by the court upon Sinaga's arrest in 2017. The media blackout tally with the national interest, which is to ensure the security of the citizens. In this context, the state is protecting itself and the citizens of the state. The Manchester Crown Court imposed a media blackout after Sinaga was arrested and tried in court for multiple convictions of sexual assault and rape towards British nationals. In the period of the media blackout, the press was not allowed to publicly report anything about the case, and the proceeding of the case is done privately. This is done in order to ensure a fair trial for all the 4 trials. The media blackout censors the verdict of Sinaga's past trials and the evidence from the jury. Thus, the jury will not be influenced by the verdict of the past trials. This is to safeguard Sinaga's position in the trial as a defendant. Secondly, the media blackout imposed by the court aims to safeguard the position and the identity of the victims and unidentified victims. Based on the substantial evidence presented, which was Sinaga's 2 iPhones, a number of victims were identified. Media blackout is imposed in order to protect the identity of victims who came forward and to encourage unidentified victims to come forward and report the rape and sexual assault. The detectives involved in the investigation figured that there were at least 70 or more victims that have yet to come. The 1963 Vienna Convention on Consular Relations is used as a reference in regulating consular relations between countries. On April 24, 1963, the treaty, which contains 79 articles on consular relations, was adopted. The convention provides a mechanism for providing consular assistance and access for each country to aid the nationals. Article 5 of the Convention mentions the active role of the consul, which acts as a representative of the state. The consul is responsible to protect and safeguard the interests of the state and the national. In this context, the consul is responsible for safeguarding Sinaga, an Indonesian national who was tried at the Crown Court in Manchester, United Kingdom. It is by obligation for the consul to ensure that Sinaga is tried under a just court and his rights were given to the full extent, although he committed a crime against humanity, which is rape. In conjunction with this, Article 36 of the Convention discusses the role of the consul, which in particular allows the communication between the consul and the national. In this case, the consul is responsible to provide the national with legal assistance without denying respect and the full extent of the national's right as a citizen. In providing legal assistance, the convention requires the state to represent or appoint appropriate lawyers for the national in facing trials in order that they receive fair treatment and their rights are protected. However, the rights mentioned in Article 36 should only be exercised tally with the laws of the receiving state. The country of origin has the right to receive notification from the local government. However, some countries often do not notify the accused or convicted to come forward.
The first one is the possible factor that drove Reynhard Sinaga to commit the crime, which is the openness and the acceptance of the gay community in Manchester that he cannot actually experience back in his home state, which is Indonesia. So as we all know, Indonesia is seriously banning the LGBT community in its state. As the former member of the House Representative Mahfuz Siddiq issues that LGBT issues can disrupt national security, identity, culture, and the faith of the Indonesians. And the citizens itself also not in favor of this, as they too have a strong stand in canceling the LGBT community in their country, as there are so many anti-LGBT demonstrations going on in Indonesia after this case explode. So this is actually giving us a big picture that both the citizen and the leader is not in favor of the LGBT community in Indonesia, and they actually believe that the root of the heinous crime that Sinaga committed in Manchester is because the LGBT the ideology of the LGBT. So the second part will covering the responsibility of the home state, which is Indonesia. So the responsibility is to ensure the welfare of its citizens, as stated in the Article 28D, Section 1 of the Indonesian Constitution, mentioning that every person shall have the right of recognition, guarantees, protection, and certainty before a just law, and of equal treatment before the law. So this actually giving explanation that the Indonesia actually have their own representative to represent the Indonesian government in the United Kingdom to protect and ensure a fair trial for its citizens, in this case Reynhard Sinaga, and which they also doing, where the Indonesian embassy also stated that they had been following Sinaga's case to ensure the full extent of a just trial, and they also assisted Sinaga in scheduling the consular visits from his family and his attorney at the detention center. Okay, now the use of diplomacy in settling the legal cases. The use of diplomacy of both the Indonesia and United Kingdom. So the use of diplomacy in this case is dynamic in nature, as the outcomes could be good or could be worse depending on the whether both states could reach a settlement. So they use diplomacy to settle the legal case, but not to intervene, Indonesia especially, not to intervene in the internal affairs of the Manchester, to respect the supremacy of the law of the Manchester, United Kingdom. So this diplomacy will bring about a healthy agreement for both Indonesia and Manchester, United Kingdom, to fulfill a win-win situation for both countries.
The Rohingyan are among the many ethnic minorities in Myanmar. The Rohingya, which in early 2017 numbered around 1 million in Myanmar, is one of the country's many ethnic minorities. Rohingya Muslims are the largest percentage of Muslims in Myanmar, which the majority living in the state of Rakhine. They have their own language and culture, and claim they are the descendants of Arab traders and other communities who have spent generations in the region of Rakhine.
The internet is so embedded by the issue of Rohingya for these past few months, And the increasing number of refugees in Malaysia is undeniable, and this problem has been around ever since. However, during Movement Control Order, there was a boat carrying some Rohingya refugees, but due to the enforcement of the MCO, Malaysia has been left with no other option but to turn away the refugee boats, and this action was in line with closure of Malaysia borders to curb the spread of COVID-19. So for our second case, our aim is try to explain the approach taken by the government to resolve the issue of Rohingya refugees seeking sanctuary from Malaysia.
Back in 2017, Malaysia wanted to show to the world that the country were willing to help the Rohingya to provide them temporary shelter as the international finds a solution to this crisis. In the year of 2017, Malaysia's Coast Guard would not turn away from fleeing violence in Myanmar by Rohingya Muslim and is willing to provide them with temporary shelter.
The 1951 Refugees Convention became a reference regarding the issue of the refugees, and it is the key legal document that defines who a refugee is and set out the right of individuals who are granted asylum and responsibility of nations that grant asylum. Malaysia is not among states that ratified the Refugees Convention, so Malaysia has not direct responsibility to grant protection. However, even though the state does not ratify the Refugees Convention, the international community have a general duty to provide international protection as a result of obligation based on international law, including international human rights law and customary law. Apart from that, the agents step in by offering aid and help refugees in response to the issue in Myanmar. For example, some states in Southeast Asia has taken the Rohingya refugees. However, some stated that this approach is not enough because it does not address the root of the issue, which is persecution of the minority group. And this happened because Asians tried not to involve much in Rohingya issue because of their policy, which is non-interference.
The first factor is about the legal status of the Rohingya. The government has refused to give the citizenship of Rohingya, and as a consequence, most members of a group have no official document, effectively rendering them from becoming stateless. Apart from factor, there are also impact of why the Rohingya refugees seeking for sanctuary from Malaysia. The impact is how the region respond to this matter. Sometimes protesters have gathered in towns in Pakistan, India, Thailand, Indonesia, and Bangladesh to denounce Rohingya killing and persecutions. Bangladesh Minister of Foreign Affairs condemned the attack in Rakhine as a genocide in September 2017 and called off the Myanmar government to stop its campaign and end the violence.
By the international criminal law, criminal responsibility for serious crimes is of essential importance in terms of respect for the rule of law, deferring future violations, and providing victims with redress and justice. And the second case, about refugees, the set of rules specific the rapid and unimpeded passage of humanitarian relief in armed conflict. The refugees of the Rohingya by the Myanmar is one of example. With support for the international community, the Malaysia government will continue the hostels who were already represented in the country until they get transferred to the third country.